I think we can get started here with our third and concluding session. The main speaker is Harvey J. Goldschmid. Jeff Miller had mentioned that Harvey was a mentor of his, and he certainly is a mentor of mine. He joined the Columbia Law Faculty in 1970, which is the year I started at Columbia as a law student. And thereafter, I went on to clerk for Judge Paul Hayes, for whom Harvey had clerked. And thereafter, I went into teaching, in part at Harvey's encouragement. He has been a great inspiration to me, and I can only wish I could come close to matching his accomplishments. In addition to having been a faculty member at Columbia since 1970, he is a former commissioner of the Securities and Exchange Commission. He was also general counsel of the SEC, special senior advisor to the chairman, Arthur Levitt. He was the reporter for the American Law Institute's Principles of Corporate Governance project. He's been a consultant to the Federal Trade Commission on antitrust policy, and other accomplishments too numerous to mention. He is he has his bachelor and law degrees from Columbia, where he was magna in both college and law school, and articles editor of the Law Review. He is the author of numerous articles and the editor of case books. Again, his list of accomplishments is too long, really, to recite at length here. The first commentator on Harvey's presentation will be Tom Morgan, the Oppenheimer Professor of Antitrust and Trade Regulation Law at George Washington University Law School. Now, Harvey has done various jobs, but his entire academic career has been at Columbia. By contrast, Tom doesn't seem to be able to hold down a steady job. He began teaching at University of Illinois after graduating from law school in 1965. He was later professor and dean at Emory Law School, then at Brigham Young, and since 1989 now he has been at George Washington, and he teaches in the areas of antitrust and economic regulation and professional responsibility. He was one of the two associate reporters for the ALI's Restatement of Law Governing Lawyers. And our last commentator for the day will be John Dunn, from whom we heard some very interesting comments in the Q&A session from the second session at the end of the morning. John is a partner at Jones Day, doing largely an international practice, as you could infer from his comments. John has his BA degree from Marquette and his JD from Georgetown. Harvey, you want to stand up here?
With an enormously kind introduction of the kind you just heard from George, you can see why he had so little trouble getting me here. And George and Jeff are two of my favorite students, and it is a great pleasure to be here. My focus today is on lawyers, and think of in my mind's eye of publicly held corporations. That means if you think about the constituency in the United States, we have roughly 4 million corporations And I'm talking about the largest 10 to 14 or 15,000 in any given year. But what I have to say is relevant to other gatekeepers, and one has to remember this is a systemic problem we've had in the late 90s and early 2000s in terms of the scandals. And so accountants and credit rating agencies and others, part of what I say you can take is also directed to them. And it's also directed, of course, to lawyers of smaller public corporations, nonprofit institutions. If we have a problem here, as I talk about reporting up, the question is why should the university be any different than the public corporation? Shouldn't many of the same rules and intuitions be carried over to the large nonprofit corporation? Let me begin with three basic propositions that will explain my cautious optimism about the accountability and responsiveness to public policy concerns of lawyers today. First, I ought to give you a corporate governance observation. I believe that directors, and particularly independent directors, are the most important actors in our corporate governance system. But the scandals of the 1990s and early 2000s have indicated no matter how active, no matter how demanding those directors are, they're heavily dependent on disclosure and on the efforts and effectiveness of various gatekeepers, most notably accountants and lawyers. Here we're dealing solely with lawyers, and so let me focus on them. And my first basic proposition is the result of corporate governance reforms in Sarbanes-Oxley and what the SEC did, as explained so well by Richard Humes, to implement and build on Sarbanes-Oxley. Lawyers for public corporations are under far more pressure today than ever before. The second proposition, part of the pressure to perform effectively comes from new regulatory structures. On some basic level, we have federalized, at least partially so, a meaningful amount of legal obligations. And as you'll hear me develop it, I think that's a very good thing. We do have a new, more rigorous, and still developing system for the regulation of lawyers at the federal level. Third, and I won't spend too much time on this, but we must keep in mind that even good legal rules or regulatory schemes are of only limited value unless they're vigorously enforced. Real people are motivated and driven by reputational concerns, by decency, by pride, by professionalism, by like values. But enforcement, legal sanctions, are critically important incentives to proper conduct. In the 1990s, because, for example, of flat SEC budgets, wholly inadequate SEC budgets is a more basic way to put it, the central bank case and the PSLRA in 1995, or at least provisions of it, accountability pressures on lawyers for public companies were sharply diminished. In recent years, new enforcement powers and resources for the SEC have given continued hope for vigorous enforcement. But enforcement efforts, current enforcement efforts, are under counterproductive pressures today. There's a new backlash in the business community, and whether enforcement will work in these areas is still very much a work in progress. In general, we're dealing with young, vulnerable, and still quite imperfect regulatory schemes for lawyers. And I'll make a few suggestions for enhancing responsibility and perhaps improving the systems. Let me begin with Section 307 of Sarbanes-Oxley, and this will repeat some themes from this morning and the idea of reporting up. There were 5 basic decisions made, you remember, by a virtually unanimous Congress when Sarbanes-Oxley was passed in 2002. Now, I won't swear that each member of that Congress understood each of these 5 basic propositions. One, reporting up would significantly enhance the critical gatekeeping role for lawyers. It empowers lawyers, in language used this morning. I guess one thing to keep in mind here is this is perfectly consistent in terms of reporting up with the entity definition of the lawyer's responsibility and the traditions of the bar. The second thing is, I think it's particularly needed for the reasons Jeff Miller set out so well this morning. In this new competitive environment, the ability to get to senior management, to boards of directors, to independent directors becomes particularly important. And getting rid of the etiquette problems, of the lack of contact problems, forcing lawyers to report up things that can seriously hurt the corporation is all to the good. Second basic value or policy decision made by Congress. Consistent with corporate governance developments over the past 35 years, key decisions about the corporation's vulnerability to material legal violations or other wrongdoing should be made in the end by independent directors and not in the middle levels of management or even senior managements. If there's a serious problem, before it's carried forward, it ought to get to independent directors. Now, let me digress for a second in terms of corporate governance. I began teaching at Columbia in 1970. I was just a child at the time, I should indicate. But 1970 had events something like today. It was the failure of the Penn Central Railroad. Penn Central at the time was our largest railroad, our sixth largest industrial corporation. Its failure was the largest bankruptcy since the Great Depression. Everyone studied what went wrong. It was clear from the studies done by the SEC and almost every business school in the country that the boards of directors of public corporations in the 1970s worked almost not at all. The average time being spent on the job by directors of public corporations in 1970 was 30 or 40 hours a year. How could you understand an institution of the complexity of Penn Central spending that limited amount of time? And that was true all over the corporate community. By pre-Sarbanes-Oxley 2001, there had been a dramatic change in terms of the activity of directors. By then, and I don't mean to use numbers as bright lines, but they provide a feel. The average director of a public corporation was working 150 or so hours a year. And they were checking more, they were doing more. It was a far more serious operation. It was obviously imperfect, and Enron, WorldCom, and the rest demonstrate that. But we don't know how imperfect it was. We don't know how many Enrons and WorldComs were prevented by active directors being serious about the job and asking all kinds of questions. We do know after Sarbanes-Oxley that the numbers are moving up again. More pressure on directors, more need to be active. The number, again, without trying to bright line, because obviously the time you spend at the corporation depends on the complexity of the corporation, where it is in life cycle, what's happening there, et cetera. It's something like 250 hours a year now. And what Sarbanes-Oxley did with lawyers and what's happened with accountants and others, it's forcing information up the chain of command, up the ladder to those independent directors and giving them a shot to make corrections before disaster occurs. The third basic policy decision that Congress made was focusing on the need for programs and procedures to make the system work. Again, no matter how demanding independent directors are, they cannot carry the load alone. And so just about every law firm and just about every corporation today working in the public area has reporting systems, has means of getting things up, has training for lawyers. Indeed, I can't imagine a large firm today without some kind of training program, because it's needed to know what to do, where things move, who should make decisions, when we have to go up that ladder or chain of command. Fourth proposition, and this obviously was subject to legitimate debate and controversy, although I think it was both dramatic and wise, the mandate of reporting up was a matter of federal law. This is the federalization issue that's so important. Why federalize law that's traditionally been at the state level, at least for lawyers for public corporations? And the answer is and this was suggested this morning, it's the only way to make it work. State disciplinary groups, New York's is as good as any, but the focus is on lawyers' hand in the till and matters of that type, taking from a trust fund. The idea that state disciplinary bodies were going to enforce reporting up with their scant resources anyway was just unreal. On the federal level, you have the SEC with much larger resources, a budget today of roughly $900 million, personnel of 3,800 or so, capable of enforcing those standards. And you have a large spectrum of important remedies, from civil money penalties to injunctions on through. This is now a serious mandate. The seriousness of the mandate, again, has to be taken into account with the judgment needed to not over-enforce. But I asked Richard if there had been any cases under 307 and 205, and the answer so far, I take it, is no. And that indicates a kind of judgmental concern of not pushing things at the margins. But the pressure of real enforcement resources and sanctions is clearly there. The fifth proposition, again, has been subject to heavy debate, but contrary to the comments of many before the SEC or that continue now, Congress clearly contemplated additional rulemaking beyond just reporting up under Sarbanes-Oxley Section 307. Section 307 reads as follows: the Commission shall issue rules in the public interest and for the protection of investors. Those are code words meaning you have large discretion in terms of the Commission. Setting forth minimum standards. Now, minimum standards has an S on it, I want to emphasize, of professional conduct for attorneys, including, and then goes on to talk about reporting up. The words minimum standards and including were critical to the SEC consideration of various reporting out scenarios and perhaps more in the future. This is a provision, Section 307, with, I believe, large future potential. Among the candidates for possible rulemaking in the future when it comes to the legal profession are the role of, and here I've just got a list of candidates without endorsing any one, the rules for independent counsel doing investigations. Should there be guidelines? I think it would be helpful in general to the bar and useful. Law firms' responsibility with respect to reporting up. Section 205 is drafted in terms of individuals. No one's ever spelled out what the firms ought to do. The firms are actually working very well, I think, on reporting out, but guidelines there may be useful. Jack Coffey's idea of disclosure counsel, which Jeff mentioned this morning, is certainly one to be considered. We may want to think about special counsel responsibilities in particularly sensitive situations. Today, for instance, one of those is the management leverage buyout. When the managers in some group of financial types are buying a company and taking it private, the conflicts are overwhelming. Giving lawyers some special role there might well be useful. There may be room for special counsel responsibilities for transactions without legitimate business purpose or substance. One of the things that appeared to have been in the water in the late 90s, at least the drinking water for some, was some sense that we are narrow technicians, even though this product has no other use. And there was an AIG case of this type, but there were too many. No other use except to mislead in terms of a company's financials. Lawyers seem to live with that idea. It was a legitimate product. In itself, it didn't do anything. But they had to understand this had no other use. And should there be special legal responsibilities, whether in the securities area or the tax area, for such products? Mandatory reporting out is still another area that we have to think about, and we did. On reporting out, on a permissive level, everyone should understand the SEC's current requirements of permissive reporting out are roughly the same, although somewhat more demanding, as the ABA promulgated in Section 1.13 of the model rules in the summer of 2003. Permissive reporting out takes care of 90+% of the problem. Reporting up, rather, or reporting up itself takes care of 90% plus of the problem. If you think about questions about material wrongdoing violations that can badly hurt the company, moving up the chain of command or the ladder, one can hardly expect that along the way someone will not say we ought to stop it. And indeed, I think that is happening 90-some-odd% of the time. The question is, what about whatever small percentage is left? You can hear from me, I think of reporting up as the key to the obligations on lawyers under Sarbanes-Oxley. The question is, what happens if there's the imperfect world of something not being corrected that should have been corrected? There is always that possibility that the board is right in saying, no, we have to continue on a path. Now, the noisy withdrawal idea that was before the Commission for mandatory reporting out was one that said, in effect, if you're a lawyer and you make the noise, you don't have to turn over the documents. What you have to do is make enough noise to alert authorities there's a problem, and clearly that would have happened. It wasn't giving up confidentiality or privilege. The Commission would then come knocking on the door, and they'd have to have the privilege defenses and other things would still be there, but it would alert the regulatory and other communities, including shareholders, there was a serious problem involved. And this would have paralleled the burdens we put on accountants. Under 10A, accountants have to report up, indeed have to report out as a mandatory matter in wrongdoing situations. Why didn't we go forward? It was always a close and difficult case. For me, the problem of mandatory as opposed to permissive reporting out was it was too far from the traditions of the bar. The concerns and emotions were dramatic. Even more significantly, it might interfere with attorney-client relationships, and that had to be a concern. It would have opened up something that was discussed this morning, the potential for SEC pressure on lawyers. Why didn't you? You must report out. New vulnerability, new pressures. That might have been a serious problem. The bottom line is, for me, test the effectiveness of permissive reporting out and mandatory reporting up before doing anything further. And again, I think in 90% of the situations, that will solve the problem, 90+. There have been no reports yet of reporting out. But Richard Humes, who's here, said at a conference, at least back in March of 2005, that he periodically does get calls, receives the calls about how I would go about reporting out, and then a call comes a few days later saying no need to carry this further, everything's been corrected, which, if true, would indicate the system is working well. I'm nevertheless concerned. One, it's against the traditions of the bar to report out. In 40-plus states before the SEC's rules, and indeed before the ABA changed its rules about permissive reporting out, there was no reports, anecdotal or any other way, of reporting out of scandal and of wrongdoing. There appears to be little of it today, and I do worry about it working against the decent instincts of the bar when it's only permissive. Looking around, thinking of losing clients, thinking of what the other guy will do, it doesn't play to the best instincts of the bar to help clients. But it's a close question. And it's a close question in part because of interfering with the relationships and in part because of giving the SEC powers that one could argue against. Now, one question is, why put all this new burden on lawyers? And there are new responsibilities being put. Let me give you my pragmatic approach on that quickly. One, it does parallel what we ask of accountants, and the function of lawyers for public corporations is much the same. Accountants must be independent auditors signing off. Lawyers are the gatekeepers to disclosure. No one can have a public corporation without lawyers. And it's fair enough to ask more of them. And remember, we're asking more of everyone else. We're asking more of independent directors now. We're asking more of investment bankers. We're asking more of just about everybody in the system. Secondly, the traditional norm for lawyers, the words we use about being officers of the court, have always conveyed a sense of limit, a sense of obligation on lawyers. You've got to react to perjury. You've got to react to false disclosures by clients and other things. And lawyers, on third point, have to have their loyalty under every professional code in any state to the entity. That means more than the managers, and even more than the board. There's a basic shareholder, investor, entity aspect that's been part of our traditions. And we do give lawyers special advantages. Strong confidentiality protections were discussed this morning. My colleague Bill Simon said about that, and here I'm quoting him, "The bar has succeeded in achieving stronger confidentiality protections than competing professions. This is a great marketing advantage for lawyers." We can ask a little more of them for all of those reasons. Let me touch a part of a discussion that came from lunch and maybe this morning about the reporting up rule. I don't want to do the technical aspects of it. But there is that one sentence that was mentioned this morning, I think, that's one of the worst in the English language. It's a key sentence about triggering reporting out. It defines evidence of material violation, and it has both a double negative, which, among other things, is awful for the year in it. But let me interpret that sentence at least as I would. It says that when a reasonable attorney, and the double negative really stands for one with judgmental leeway, which obviously is necessary here, becomes aware of critical evidence that it is reasonably likely underscore, and I'll come back to it, that a material violation has occurred, etc., he or she must report that evidence up the ladder or chain of command. It's clearly an objective standard. Reasonably likely is, again, a traditional term that the Commission has used in the MD&A, the Management Discussion Analysis sections of disclosure. And there are various definitions floating around, but the one common ground is it means less than 50%. I've heard some suggest 20. I'm not sure I'd go there. But less than 50%. So if you're aware of a less than 50% chance of wrongdoing, it's got to be reported up. And the conceptual policy underpinning to that is as simple as, if in doubt, move it up. It's not going to go outside the corporation. It's up where senior officers or independent directors will be able to see it and know there's a problem, and then let them react, but don't keep it bottled up below. Where there's doubt, move it up this ladder or chain of command. I don't want to keep going too long, but let me turn to enforcement for a minute. Rules, as to lawyers and everyone else, even good rules, are of limited value unless they're enforced by legal actions in our courts. Sarbanes-Oxley recognized that in providing all kinds of new remedial powers to the SEC and in criminal areas to the Department of Justice. What Congress recognized in Sarbanes-Oxley is that corporations, other entities, individuals who comprise them, and the various gatekeepers must know they're likely to be held accountable for wrongdoing if our securities regulatory scheme is to work. Effective deterrence requires a strong and credible threat. It is that threat that creates the powerful incentives to avoid wrongdoing acts and to bring about the cultural, procedural, and process changes necessary to protect investors. For me, in my time in Washington, the words accountability and deterrence were at the core of what I thought we were doing in enforcement. Penalties must sting if they are to be effective, and if we were going to get the deterrence and the activity to prevent wrongdoing, you had to have a serious enforcement effort. And I think we did so, at least for the time I left from July 31, 2002, and left at July 31, 2005. Let me give you a quantitative feel for what I'm talking about. When I came back to Columbia Law School after being general counsel of the Commission in 1998 and 99, I would lecture a class. The SEC had the capacity to bring somewhere between 350 and 450 cases a year, and this for the wide set of constituencies that the SEC was overseeing: broker-dealers, investment advisors, insider traders, disclosure failures, etc. In the year 2001, before I got back to Washington, the SEC had already become far more active. 484 cases had been brought. By fiscal 2003 and 2004, well over, and this was true in 2005 too, well over 600 cases had been brought. And they were more complex, more important, more difficult than any that had been brought before. In quantitative terms and dollars, and this doesn't involve lawyers, though more lawyer cases have been brought in the last years. The civil money penalties disgorged are just off the page. The SEC leveled its first $10 million civil penalty in 2002. There were 20 of those in 2003 and 40 in 2004. In dollar terms, you can take 2003 or 4 or 5 separately, and in each of those years there was more civil penalty collected than the prior 15 combined. And this was meant, again, to sting. In terms of SEC policy, which I hope still continues, if you pay a civil money penalty, which means there was serious wrongdoing involved, it cannot be insured, it cannot be indemnified, it cannot be used for tax deduction. It goes to you, and you've got to carry it, whether you're an institution or an individual. Again, accountability and deterrence were the core of all that was being done. Washington's a complicated place today, and the SEC's budget is flat again, and I am worried about the backlash, and therefore cautious optimism about the whole system, and lawyers too, is the best I can do. But you can see this is a very different world than pre-Sarbanes-Oxley, and for me, it's clearly all to the good. Thank you.
First commentator is Tom Morgan.
Thank you, George. It's a real privilege and pleasure to be here today, and an honor to follow Harvey Goldschmidt. It is with no lack of respect for the preceding speakers that I suggest that some of the comments I make today may be counter to those that you've heard, and I hope that they will at least help you put in perspective some of the suggestions that have been expressed here today. The first point is to suggest that whatever the causes of the corporate wrongdoing we saw in since 2001, or roughly that period, they were not for lack of lawyer regulation. Ever since, for at least 35 years, we have had extensive regulation of lawyers by the states acting primarily through the ABA, Model Code of Professional Responsibility, and then the Model Rules of Professional Conduct. And it has always been illegal, improper, for lawyers to participate in any form of the kind of corporate misconduct that we've read about and heard about. It has been illegal under Model Rule 1.2D, for example, for a lawyer to counsel or assist a client's crime or fraud. That's probably the basic principle, but it's been an obligation under Rule 1.4B for the lawyer to keep the client informed, including the management, independent directors, whoever needs to know it, about any fraud of which the lawyer's aware. There's been another obligation under Rule 113B to report that information up the ladder. Indeed, the SEC's regulations are essentially taken from the state rules that have been familiar for an extended period of time. Under Rule 116A, it has been obligatory for lawyers to withdraw from any fraudulent conduct in which their client is involved and of which they are aware. When they withdraw, they have been permitted to do it noisily and to announce to anyone with whom they've corresponded, any opinions they've issued, withdraw those opinions, make clear that there's been a problem. Under Rule 1.6B, as it has existed under the law of most states and now does in the ABA model rules, there is permission to disclose the intention of the client to commit a crime or fraud, or even the fact that the client has committed a crime or fraud, to the extent you can do anything to try to mitigate the effects of that. This is all part of the new Ohio rules. It's been part of your rules for a long time. In addition, under Rule 113C, you have a right to report out, not just report up. And under Rule 4.1B, there may be an obligation, there is an obligation in many circumstances, to make affirmative disclosure to persons who may be injured by a crime or fraud being committed by a client. In short, there has been an obligation of lawyers not to participate in wrongdoing, indeed to try to interdict wrongdoing for an extended period of time. The suggestion has been made, and it's regularly made, that, well, those were state rules. Now we've gone to the serious stuff. And it's absolutely true that the states have done a bad job, a terrible job of enforcing these rules through the disciplinary system. If the truth be known, the states have done a lousy rule in general in using the lawyer discipline system. It has not been effective in a great many jurisdictions with respect to a great many things lawyers have done. What has substituted for the disciplinary system in reality is the system of lawyer malpractice. The world of lawyer liability has exploded, particularly since about 1990 in the savings and loan cases. There has been enormous liability. Major firms with $30, $40 million judgments rendered against them. Cases filed in which, regardless of how much insurance they have a retention, so it's costing them money out of pocket. Other cases in which insurance has not been available because they were found to have participated in the fraud themselves. So we're talking about a system that flies under the radar, or in the sense of people who are only counting discipline cases, but which has led to an enormous amount of education and training in law firms, primarily stimulated by lawyer malpractice insurance companies, who are very anxious for lawyers to understand what the law is. And I'd suggest with great respect that this system it should not be overlooked as we think about what the rules should be. Sarbanes-Oxley, in short, made this a federal requirement. That is not trivial. It has certainly attracted a lot of attention. But the point I'm trying to make is that federalizing it did not ultimately change the dynamics of the problem of getting lawyers to act. I hesitate to use an analogy here, but I think the easiest law that could be passed today would be a law against shootings in public schools. We've had a lot of recent cases, and somehow we think, boy, if we just pass a federal law, that'd solve the problem. We all know, if we think about it for a few minutes, that we've had state laws against murder for a long time. And the challenge is trying to understand what the dynamics are of the situations that lead to people not following the law, rather than to suggest that adoption of a new body of law is somehow going to solve the problem. I would suggest, just as a footnote, that Professor Miller's very interesting suggestion this morning could be implemented today by any corporation that wanted to do it, by any law firm that wanted to do it. There's nothing in the regulation of lawyers that prevents any of that happening now, or would have prevented it before Sarbanes-Oxley. Second, again with great respect, because I know I'm certainly sounding like a lone wolf on this point, I think the term gatekeeper is terrible. I'd suggest to you that it really gets in the way of thinking about the lawyer-client relationship. Gatekeeper, when you read the articles on gatekeepers, you realize that it's not a terribly clearly defined subject. At one level, it is a term that is used to describe a positive or just describe the world, in the sense of saying lawyers are around companies and clearly have influence. That much we all agree. Second is a notion that somehow wrongdoing couldn't occur if it weren't for lawyers. And I respectfully suggest that isn't true. A lot of wrongdoing, environmental degradation, for example, takes place where lawyers have not been directly involved in the situation. And the task of trying to know what's happened, trying to report what's happened, is a challenging one for lawyers. Third, there is the kind of normative view that we really ought to set up a kind of group of screeners. And this is what we heard in part with the Coffey proposal and the Gordon proposal this morning, that there really ought to be a group of people who certify, kind of give a good housekeeping seal to the disclosure documents. With all respect, again, that is virtually impossible to do unless you can assume perfect knowledge or sufficient imagination to anticipate where most of the hidden problems are. Now, we can all trout out Enron and say, gee, people should have known. But there are an awful lot of circumstances in this world that are not remotely as straightforward as that. My own view is that the model we ought to be striving for is the lawyer as counselor, the lawyer as goader toward proper reporting, proper conduct, rather than as gatekeeper. This has a couple of effects. One is that's how lawyers try to think of themselves. And as we saw this morning from both of the general counsel who were speakers, basically the companies want to do the right thing. The number of companies out there who are really saying to themselves, how can we dodge the law and how can we figure out a way to be crooked, is, I won't say it's zero, but it's relatively few. And if you've got one of those as your client, you just really ought to get out of that representation pretty quickly. The name of the game ought to be to say to ourselves, how can we structure this relationship in a way that will help stimulate a kind of trust, a kind of mutual respect of the kind that Professor Miller was suggesting may have occurred, or may have existed back in the club era, in a world that we clearly now understand to be the market era and a competitive era. That's a challenge. I don't have a complete answer to it by any means, but I think that that's the right direction. The second point of this is that if we could get to that point of view, perhaps we could come closer to avoiding some of the problems we've talked about in terms of the attorney-client privilege. Because there is the common interest privilege, or the common interest understanding of the attorney-client privilege, where if you release information to somebody with whom you have a common interest, you have not waived the privilege. We're going to get ourselves into a situation where if you start releasing the internal communications between one lawyer and another to outside counsel, who will be deemed to be a gatekeeper, who will thus be deemed to be an adverse party, in effect, we're just going to make this problem a lot more complicated than it has to be. We're moving in the direction that courts are at least beginning to catch on to this idea that auditors have a common interest with the company. We talk about them as gatekeepers, but in fact, they too have an interest in trying to help this company report accurately, comply with the legal requirements. And if we can get everybody on that team, then we can begin to clarify some of these attorney-client privilege issues, I think, in a way that will be helpful. Third, I'd suggest to you that there's a downside to noisy withdrawal. What I'm seeing, and I don't claim to have omniscience in this area, but what I'm seeing is the use of the power that attorneys are given by this rule and the requirements that they see that have been generated through Sarbanes-Oxley as tools in what I would describe as corporate politics. We've all kind of assumed that the corporation has a single purpose, a single direction, all the people in it are either honest or dishonest or whatever. The fact of the matter is there are multiple units in most corporations. And many times you get somebody in the company who really wants her point of view or his point of view improved, and thus will assert that the other person's point of view is illegal. It's not only illegal, it's so illegal I got to take it to the audit committee. And it's so illegal that it would create an obligation to report under Sarbanes-Oxley. And that kind of misuse, I'd suggest, by anybody's standard, of the obligations we're creating is a problem that would only be exacerbated by noisy withdrawal. I've suggested as well that noisy withdrawal is the worst of all worlds. We now have a system, as we know, of permissive withdrawal, but noisy withdrawal is what I've described as a game of charades, in which you wave your arms and but you can't tell people what you're really trying to tell them. And if you send to the market information that the law firm or a lawyer withdrew at XYZ company, that's almost certainly going to have an impact on investors that may or may not be accurate. That is, the people who are holding the stock are going to be less wealthy tomorrow than they were yesterday. Some point they will hopefully learn enough information to make it all cancel out. But the idea that more information is inevitably better, at least if it's bad or confusing, ambiguous information, I'd suggest to you is one we have to be very cautious about. Finally, I'd suggest that one of the biggest threats to this whole world of increased reporting and increased sensitivity to these fraud issues these days is the work of the ABA task force on the attorney-client privilege. I don't mean to attack those individuals personally. They put in a lot of time and effort on a volunteer basis to try to help improve the situation. But that committee has gotten two propositions through the ABA House of Delegates that I think are problematic. First is a suggestion that corporate lawyers now have an obligation to the individual constituents in the organization to protect their attorney-client privilege in interviews with them. Now, I certainly agree that you have to tell people that I am not your lawyer, I'm the corporation's lawyer. If you want your own lawyer, you got to go hire one of your own. But that's a separate question from saying that you, the corporate counsel, have a duty to those individuals to protect their individual rights as distinct from helping the client, the corporation, clean up whatever mess there is to clean up. In my judgment, the obligation is to the company, your client, not to those individuals. And the ABA, as I say, has taken a directly contrary position. Second, the ABA has, the task force has resisted efforts to get credit for engaging in internal corporate activity designed to acquire information and then waive the privilege in dealings with the Justice Department or the SEC or anybody else, in short, in an effort to try to clear things up. What I'm told right here in the task force meetings is, as Richard was talking, Richard Humes was talking this morning, that they like the idea of limited waiver as a substantive matter, but the politics of it today are we've got to fight the evildoers in the enforcement agencies rather than genuinely try to help our clients get out of whatever mess they've inadvertently found themselves in. I'd suggest to you both of those are dangerous directions, and that we at least ought to be aware of them as we think about the many problems we've talked about today.
I suspect that Harvey's going to have some responses to that, but first let's get our last commentator, John Dunn.
I'm going to stand up because it's nearly 2:30 in a Friday afternoon, and I don't know about you folks, but after the week I've had, I wouldn't mind a little activity to try to stay awake. I've been here since about 10:45 this morning, and I've been wondering up until this very moment, why am I here and what can I possibly contribute? I'm still not clear on that. I'll start off with a few perhaps random thoughts, so excuse the James Joycean stream of consciousness. Thank God you're here. I was beginning to think I was in a real hostile territory. But you and I are properly seated next to each other. Secondly, it's always fun to be at Case. I have a family connection here, as my wife is a 1975 graduate of Case, and as she reminds me whenever I get uppity, she was the first woman to graduate first in a Case Law School class, so she's smarter than I am, in addition to being a hell of a lot more attractive. Another random thought, what goes around comes around. Years ago, when I was a pup in law school, we talked about national student marketing, and J. Marion Epley, who, if I'm not mistaken, a partner at White & Case, was the first lawyer to really be severely reprimanded for participating in the release of a inaccurate, misleading prospectus. So we thought that was a big deal 30-some years ago, and we kind of forgot about those things, and now here we are. One of the reasons I think I'm a bit inappropriate to be addressing this whole subject is that I don't make my living as a securities lawyer or as a Sarbanes-Oxley lawyer. I'm an international M&A lawyer. I spend virtually all of my time representing non-U.S. companies, some of whom happen to be foreign private issuers subject to U.S. securities regulation, and occasionally I do work for U.S. companies. I suppose the aspect of my life that makes me somewhat suitable for participating in this discussion is that I am one of a handful of Jones Day lawyers who have been designated by our managing partner to be the gatekeeper, the conscience of Jones Day insofar as our efforts to comply with Sarbanes-Oxley are concerned. That's no small task when you consider the fact that we've got more than 2,000 lawyers spread throughout the world, 10 offices in the United States, 12 offices outside of the United States. Getting that large a group of people to agree on anything is no small task, even in the Jones Day system with its noteworthy top-down management policy. And so I thought I'd talk just a little bit about what we do and what our experience has been. I have no reason to think or believe that our experience is either in or out of the norm. It's just what our experience is. First of all, I can tell you we take this stuff really seriously. It's like the old story with the guy beating the mule upside the head, and why are you doing that? It's a bad way to get the lawyer to, or the mule to cooperate. Yeah, but I got to get his attention first. In that sense, there's no question about the fact that 307 sharpened the focus. But it was, as Professor Morgan has properly pointed out, a focus that was already fairly sharp and got sharper as a result of intense pressure from, alas, the malpractice liability insurer that we're fortunate enough to be underwritten by. What we do is provide a comprehensive education program, including an annual certification program on a global basis, the same we do with insider trading. And then I suppose the key elements of our program are we insist that any judgment call about up-the-ladder reporting not be made by the lawyers who are involved in the client relationship. We treat it the same way we treat the issuance of legal opinions. In our system, not like others. No lawyer who's actually involved in a transaction can sign off on the legal opinion. We don't want to avoid potential for appearance of having too much skin in the game. And so I get involved, as do a half a dozen of my other colleagues around the world. In this case, all of the lawyers, save one, are U.S.-based. We have one London-based lawyer who participates in these deliberations. The judgment calls are, in principle, to be channeled to one of us. The tough issues for us in terms of drafting, in case you care, I'm sure you do. Oh, sure. Credible evidence. And by the way, it's not a question of drafting, really. I mean, all of this hoopla about reasonably likely, yeah, it's not a problem. I mean, it's not tough to figure that out. In our world, the three really toughest issues. Do we have credible evidence of a material violation? Maybe everybody know what reporting up the ladder means? An attorney appearing and practicing before the SEC has an obligation, if that attorney acquires credible evidence of a material violation of law, to report that up the ladder, initially within his or her employer, then ultimately to the board of directors level, and under most circumstances to be satisfied with the response to that report. So that's the regime that we're responsible for trying to administer. It's really hard as an outside lawyer to have a comfortable judgment as to whether you've got credible evidence or whether what you're seeing is what you referred to. We got a real fight going on inside the corporation. So one guy decides that the way to get even with the other guy is to try to blow the whistle on it. And somehow we get caught in the middle, and those are really hard things to determine. But the thing that drives me and us the craziest is appearing and practicing, whether we're appearing and practicing. Now, like a lot of issues, there's a lot of black and white, but what we sweat and die about is the gray area. Clearly, if we are historic corporate counsel to a U.S. corporation and we're reviewing their 10Ks and we're giving them regular advice about disclosure, we are appearing and practicing, we're pregnant, there's no questions to be answered in that regard. If we're handling an arbitration in Shanghai, if we're doing a competition law audit in the European Union, if we're doing an infrastructure project in the mining sector in Australia, all of which can get us a lot of information, and we're responding to audit letter requests, as we're obliged to do, in which we're reporting information. Are we appearing and practicing? No answer required, but those are the things that drive us crazy, because that line is a really, really hard one to follow, as is the line about non-appearing for an attorney, for us. I think I've been involved in maybe 12 cases where we concluded we had a reporting up obligation. Under those circumstances, our rules require that 2 Jones Day lawyers personally visit the individual to whom we're making the report. This isn't done by email or telephone. And boy, it's something we don't like to do. I mean, it's a scary situation because you don't know where this is going to go. In most cases, we conclude that, in fact, we didn't have credible evidence. The response back to us persuades us, whether we were caught on the crosshairs of the inter-company feud or not, it persuades us that there is not credible evidence of a material violation. In other cases, there was clearly a material violation, and corrective actions have been taken that allow us to be satisfied. And in 2 cases, one of which I was involved in the last month, we terminated a client relationship. We got back a response. It was within the range of reason, and you know what? We didn't believe it. And it was a significant client relationship with a trivial amount of appearing and practicing. I mean, it was essentially a foreign-based representation. We did work for this company in 6 countries around the world, a limited amount of U.S. work. Unfortunately, if you want to look at it in this way, that U.S. work arguably came within the appearing and practicing framework, and we were out of there. And despite some of the cynicism that, with good reason, exists about the private practice of law, I mean, we are, after all, a multi-billion-dollar global business. You know, we don't want to do business with people who we don't trust. And we don't do business with people we don't trust. And yes, the regulatory aspect counts, but we care about our name even more than we care about the fear of sanctions, the fear of publicity. Because if we can't be comfortable with who we are, then we're not going to be much good to our clients. And the great thing about the life of Jones Day, and I think this is probably characteristic of most law firms in this community and perhaps even in this region, is that still counts for us more than everything else. And so there's never, ever, ever, I'm happy to say, been any doubt in my mind that if I made a judgment, or if any of the other colleagues of mine who participate in these judgments made the judgment that we had an obligation, and we reported up, and the client didn't like it, and sometimes they don't, or if, apart from the client's reaction, we decided we didn't want to be there, I know I have 100% full support, unquestioned, of our managing partner. So that is the ultimate tone at the top that people talk about so much. And I'm going to ask that I wrap up with just maybe 2 other observations about comments that have been made today. I'm a corporate lawyer, so I think in very practical terms. I don't have great philosophical positions. You can't afford to have that in my line of business. So I don't get all that hung up about this kind of states' rights issue about state regulation of whether federalization of the regulation of the legal profession is a proper or appropriate road to be followed. I would say that if you're going to erode state regulation, why don't you take a shot at compensation? that's where the ammunition would be a lot better drafted, and I'm a little puzzled by where there's been so great reluctance to take on compensation issues directly, which to my mind drive all of this, the vast majority of these problems. The greed, as we heard discussed earlier today. And the second thing is, we'll talk about this maybe a little bit more. I really don't share the view that we are like accountants. Now, that may be a bit of chauvinism on my part, I concede. But I think we have historically a much different role in the life of our society and in the life of a corporation than accountants do. And as they always say, don't worry, some of my best friends are accountants, so that's not, that's not a personal observation. And with that, I hope I've added a little bit to the discussion, and we'll talk some more, I hope.
I think this is going to be, I'm sure there's going to be lots of comments, including, I think, Richard Hume should have an opportunity to respond. But first I want to let Harvey reply, and then maybe Richard can reply.
What would I add? Let me try to just sharpen where there are differences and why. Focusing first on Tom Morgan's discussion, which I thought was very good. One, lawyers have been extensively regulated under ABA rules, the original 1984 draft, and then the changes made, and going back some. But there always was some ambiguity in those drafts. 1.6 required lawyers to keep things confidential unless they were a threat to life or health. You could find ways around that, and that's why I said 40-some-odd states had ways around that, but you had to work hard. 1.13, the reporting up rule, was far more ambiguous than Tom stated it, but I would have tried to read it that way too. And the non-ambiguous, you've got to report up. The big difference was who took those rules seriously and what was done with them. Now, Tom and I agree entirely that disciplinary systems didn't deal with this at the state level. Tom says the cure was malpractice action. There clearly has been some growth of malpractice action. But remember, you need a disaster before you get a malpractice action. And compare it in your minds to the system we use for disclosure and the securities laws all through. You have private lawsuits in the securities area, but much more scope in those actions to pick up disclosure problems as well as total failures, which is generally the malpractice context. But you have the whole SEC set up. For accountants, you have the new PCAOB with a budget of roughly $150 million in inspection results. When you talk about seriousness of oversight or pressure, the federal system doesn't go off on malpractice. Now, if you think malpractice will work, then you ought to reject any idea of federalization. But you can see my skepticism about that. In terms of, and in a way, John Dunn's description of Jones Day, which was very attractive, indicates the change that's been brought about and just what we meant, or at least I meant to see happen. By the way, I'm delighted. I no longer have to do disclaimers, but when I use we, I shouldn't. I'm gone. But what you wanted, a program and procedures and review and thoughtful looks, and most of the hobgoblins of, selfish motives, et cetera, in the corporation get taken care of by serious lawyers and law firms, or if it's reported up, somebody says that's nonsense and explains it, and it's taken care of. The idea is get it up. Don't have it taken care of by driven executives at middle management or somewhere like that. In terms of the gatekeeper terminology, good minds can obviously differ. I kind of like it, and I like it for the reasons that John really described. It conveys the sense of independence, an obligation beyond some tightness to the client, and a kind of consciousness about what you're doing. There ought to be, both for lawyers and accountants, a kind of, the way I put it is constructive tension. Yes, they're the client. Yes, I'm going to try to do everything I can to help them in terms of the entity. But I also have other responsibilities and obligations, and that's what people have to learn and accept today, at least, and that's why. Now, in terms of the way this works, Tom and I both have as a field antitrust or industrial organization, which I do other than securities. Much, and you can see the paradigm of what goes on, much price fixing, for instance, historically, which is a felony of serious nature, occurs at middle levels of the corporation. It's executives driven here or in this subsidiary, and they do something that's plain foolish. Reporting up will get that information up to levels. If you leave it at that subsidiary level, at the other levels, you're asking for continuing problems. Now, for antitrust lawyers, Sarbanes-Oxley, let me tell an off-the-record story. One of my favorite people in the world is a co-author of an antitrust casebook, who I won't name, but his initials are Robert Potofsky or something like that, who was chairman of the Federal Trade Commission. And Bob and I played tennis aside from our casebook while I was in Washington. And one day he looked at me as we changed sides and said, "Why'd you do that to me?" And I said, "Do what?" And he said, "I wasted 2 days of my life being trained at his law firm where he was counsel about reporting up serious antitrust problems." It was terrific to hear. And Jones Day's system is terrific to hear, and that's the pressure, and that's what's been created. In terms of noisy withdrawal, which of course we didn't go to, there was no ambiguity there. I mean, that was a problem with it from the standpoint of many lawyers. If you resigned for professional reasons and told the SEC that's why you resigned, no ambiguity at all. The commission was going to be at your door. You were indicating there were serious problems. The question is whether that created too much tension or would interfere with the relationship or other things. But I don't see any ambiguity in it at all. John's right. Compensation's a problem. But compensation is one, there are the SEC rules on disclosure, and I've never been able to figure out what to do with it. It's high, it's too high, it may be immoral at times, and we certainly want to put more pressure on the compensation committee to be serious, and we certainly want disclosure, but it's very hard to figure beyond that. Congress tried to step in several times and didn't create anything. And one of the rules in Washington for me was before you do anything, you ought to be relatively sure you're going to do more good than harm. Compensation is just a very difficult issue. John, I don't know, accountants, I mean, I consider them on the same level. Indeed, they consider us inferior in many ways. But we ought to understand the obligations they've been willing to take on. They do have reporting up, reporting out. They do have an independence obligation they accept. And after Sarbanes-Oxley in areas we can't go into, with the pressures brought on the accounting profession, I can tell you now in counseling, it's a different world. The quality of the work they're doing, their willingness to stand up, the quality of audit committees today are dramatically different than they were before Sarbanes-Oxley. And I think the luster, the decency, the honor of the accounting profession has very much come back in the real world. Aside from Jones Day and any other law firm in the room, I'm not sure that's true of the law. Anyway, that's the comments.
I can probably do it from here.
Whatever you prefer.
Oh, Richard, thanks.
Thank you. Going back to what John said about the foreign practitioners, I don't really know enough based on what you've told me, and I'm sure you don't want to share more to weigh in on that. But I was really delighted to hear what you had to say about what's going on at Jones Day about addressing issues under Part 307. I don't want to be redundant to what Harvey has said, because I think he's really saying the same thing, which is that to the extent the rules are affecting the culture and that reports are being made by either in-house or retained counsel, and the companies are addressing those issues, so that lawyers don't have to withdraw, or they are only withdrawing where they have discovered that they've truly got a relationship with a client that they don't want to continue, then I think that's a good development. I said earlier this morning, I think before you got here, that I would be perfectly happy if the commission never had occasion to bring a case against a lawyer under Part 307 if the rules are working because the reports are being made within an issuer and they're being responsibly addressed. So this is some of the best empirical evidence that I've heard, so we're delighted.
Do something with the appearing and practicing definition.
Well, I should say on that, that's an old commission definition. That
Yeah.
wasn't new for this, but it does have a lot of reach. But
Well, it does have a lot of reach in a multinational, multidisciplinary law firm. If you're on Wall Street, there's probably a better than even chance that there's not a close call because you don't have a significant litigation practice. You don't have a significant tax practice except as it exists to support your corporate practice. When you get out in the real world, you find law firms like Calfee Holder, law firms like Jones Day, like Baker Hostetler, and everybody else in this city and otherwise who have practices that don't fall into quite those nifty little categories. And that's what drives that issue and makes it so difficult for us to act in good faith and make sensible decisions on.
I'm first going to ask a question myself, and it's a question that's been in my mind throughout the day, and I guess actually it's addressed all three of the speakers, because one thing I found a little strange was that although at times Tom and John seemed to be lighting into Harvey and disagreeing with him, at other times they were saying, well, you know, the rules, it's been this way all along anyway, in which case I'm not sure what the fight is about. But my question is this: talking about the duties of lawyers and compared, for example, with the roles of accountants, I think it's understood when a client talks to an accountant that the purpose is for disclosure to the world. I think traditionally the understanding in talking to a lawyer was that the statements were privileged and confidential. Are we moving toward a point where lawyers would have to give a Miranda warning to clients? Anything you say to me could be subject to disclosure.
yeah, George, remember, reporting up that ladder is not going outside. There's no Miranda stuff in that. It's just moving it to decision-making levels at the corporation that are independent, dispassionate, and will make good decisions. It's only when you go outside.
Well, first of all, there is still the reporting out, and there are also are issues with the waiver in government investigations and so forth.
Oh, well, that's a different issue in terms of, but even, you see, the noisy withdrawal didn't ask anyone to waive. All they said is, let us know, put up a red flag, and then the SEC would have to use traditional litigation practice to find out what's really wrong.
See, I'm sorry, but that. But by the way, I don't think we are in disagreement. If I, to the extent I represent a private practice perspective, and I only represent mine, which is not, but I'm generally in the minority. I may well be on this too. I don't think this is such a big deal. It doesn't change our values as a law firm. It changes some of the process and mechanics that we go through to ensure universal enforcement of those values. But we never wanted to do business with bad people. Ever. Sometimes we've made mistakes. Charles Keating is probably the best example. And it cost us $100 million. So when you have that kind of experience, you that tends to sharpen your focus on this sort of stuff. But in terms of the noisy withdrawal, I mean, one of the really fundamental differences is accountants had to make their relationships with the public company public. It was in their proxy statement. I want the Lubrizols of the world to be able to consult with the Jones Days or the Calfee Holders of the world without having to make the fact that they've consulted with us public. It is intended to be private. And when you tell me that when I've consulted with them in private and I don't like what I've seen, and having gone through the mechanics, I've then got to tell the public that I've had a relationship with somebody that the public didn't previously know I had a relationship with, and I had no right to know that I had a relationship with. That strikes me as a bit of an extreme measure. Maybe it will prove to be necessary and appropriate. And if it is, so be it. But it strikes me as a bit of an extreme measure, and it's one of the many places, it seems to me, where the analogy between the accounting profession and the legal profession kind of falls when you go even simply to the name. It is certified public accountants. It is not counselors public at law. We are different in that respect.
On the other hand, I do think it's important to see, and I think your question raises the fact that the line between those two, between lawyers as private and accountants as public, is breaking down. I think it's very difficult now to have an interview with a constituent of a corporate client and not give them what we call a corporate Miranda warning, which is that I do not represent you. The client, the corporation, will decide what to do with the information you're giving to me, and if that creates problems for you, you may need to get your own lawyer, and if you don't cooperate with me, we may fire you. The client may fire you. I mean, all of these are wrapped up in that.
Causes people to open up real quickly.
Well, I understand. when we did the restatement of the law governing lawyers, this was a big issue. And the chief reporter, Chuck Wolfram, I don't think I'm telling stories out of school, was very strong on the idea that you don't tell the employee that because you won't get any information out of the employee. Others of us, and ultimately the ALI, took the position that you are obligated to play straight with people that you're talking to, play straight in the sense of not suckering them into providing information that then can and will be used against them. But that dilemma is inherent there, and I don't mean to say it's an easy resolution, but that was I personally think you do have to disclose. On the other hand, we were talking a little earlier about information that accountants may need from lawyers to satisfy themselves as to the likelihood that what looks like a small case won't become a big case, or a case where they filed for $2 billion in damages really is going to be lucky to, if the plaintiff winds up getting more than $500. Trying to figure out what the real information is that they need to do their audit. And so there are going to be times when accountants are going to have information that is not expected to be and not required to be disclosed to the public in general.
Okay. Questions? Comments?
Let me drop a footnote then for the second on Miranda warnings, where I agree with Tom completely. This is one of the tougher areas for lawyers. You know there's wrongdoing, and you want to investigate it, and what do you owe to those employees? Your duty is to the entity. That's clear enough. But for me, you do owe them at least knowledge that you work for the question is how much further to go than that, if at all. If you tell them and you tell us anything and we think you've done wrong, we're going to have you fired. Or all of this is likely to be opened up to the Department of Justice because they're going to demand the papers.
Now, just relax. Tell me everything you know.
You're clearly going to get nothing. And so a corporation doing a serious job doesn't want you to tell them too much. On the other hand, there is just an enormous constructive tension for lawyers as to what makes sense and what is fair. For me, the minimum is to emphasize, particularly for lay people who don't understand, that I am working for the corporation and not for you, and you have to understand that. But if you tell them, get your own representation, you know you're never going to hear anything more.
I'll just put a footnote on that comes from my experience. You think this is a complicated issue in the United States. Go to Europe, where it is not universally acknowledged that company lawyers are entitled to make any claim of privilege. So that if you go through this in Germany and you're conducting this investigation, or as part of a broader investigation, and your executives talk to the German lawyer, who by any other standards would be called a lawyer, that person, because precisely he or she works for a company as opposed to being in private practice, may not be entitled to claim the privilege on the communications, at least not according to the antitrust authorities in Brussels. Okay, anybody else?
Well, I will raise one other question that this morning, one comment I made on a question I raised to Jeffrey Miller about his proposal, I wondered about the idea of contracting with someone to function as an independent expert of some kind, and mentioned outside directors. And Jeffrey's response, well, of course, that hasn't worked very well, but my situation would be different. And Harvey, your proposal is repeatedly emphasized as funneling things to the independent directors. And one of the comments from John Dunn was, why are they messing with this? Why not do something about CEO compensation? Well, as of a few years ago, supposedly, we had the solution. Hand it over to the outside directors. Well, I think there's a general feeling that handing it over to the outside directors didn't work very well. Now, this is a different situation, but I wonder how, is there good reason to think that handing decisions over, of course, when we talk about some problem with at the mid-level, if it's something that the CEO would want to go to the board anyway, well, then there wouldn't be a problem now. I suppose the question would be, if you've got a situation where the CEO would prefer that it not go to the board, and the lawyer is under pressure to refer it to the board, A, is that actually going to happen? And B, is it likely that I know Michael Eisner is a bit of unusual, at least in terms of how open he was about it, but his attitude that was widely reported when Michael Ovitz asked if the board would approve this lavish compensation package, and Eisner ticked off all the ways in which the outside directors were beholden to him, and then said they'll do what I tell them. So is there good reason to think that the outside directors, that handing this over to the outside directors would really be an effective solution?
Well, that's a fair question. My answer is, in an imperfect world, yes. If you look at independent directors today and compare them to historical times, for me it goes back to 1970, it's a dramatically different world. We are better than any other country I know in getting rid of weak CEOs. In the 80s, we talked about the imperial CEO, which had a real aspect to it. Today, boards are reacting and moving, and they're getting better information from the so-called gatekeepers, and they're getting it better from counsel. Are there still weak boards out there? Sure. But is it very different in terms of atmosphere? Again, if you use the audit committee as I was before, it was interesting. At the commission, you promulgate things based on rationale and empirical evidence and theory and your experience, and then you wonder if you're right. Watching it now, every once in a while, counseling is of counsel of the firm. It's dramatically different. There's much more demand. There's much more seriousness on the part of the directors and the auditors than I've seen. Compensation, again, is a special problem. We required independence in part by way of case law in Delaware, saying if it's independent, we'll take it more seriously. The exchanges now have rules that say the compensation committee must be independent after the Sarbanes-Oxley or during that period. The problem is it's a very hard area for directors. It's where they're functioning least well still, and I just don't know what you can do about it. I don't mind paying a lot of money to a first-rate CEO. I mean, picking up your question. I don't mind paying it, I joke with my class, to a shortstop or a rock star. But with the shortstop and the rock star, you've got an owner out there somewhere, a producer, who's not going to pay a nickel more than they have to. The audit committee, those peer relationships and other things have made them weak in a way that's a real problem. I wish I had a good solution. The problem is there, but I don't think that negates independent directors as a general matter. They've gotten much better in the real world.
Well, okay, it's 3 o'clock and we've cleared up everything, so perfect. And I think this was another great session, so thank you.
Right.
Is he being reading? Is he being recording?
I think he's